This question is from Russell, who says, the Body Corporate Committee have sent a letter notifying the tenants that we are rescinding the approval of a pet on their premises due to ongoing barking while the dog's owners are away from the unit, sometimes for hours on end. Several breach letters have previously been sent, but the problem persists. Our Body Corporate Management Company state that if the dog owners are still in contravention of the bylaws after we have gone through compliance, conciliation and adjudication, then we must arrange fee proposals from a solicitor to commence proceedings against the tenant in the Magistrates Court for the enforcement of the adjudication order. The question: is the Body Corporate Committee obligated to seek the services of a solicitor for court proceedings, and if so, at what approximate cost? Is the respondent also obliged to seek the services of a solicitor? So this particular question doesn't come up very often because it relates to a very late stage of bylaw enforcement. So as Russell has highlighted sort of in his question, the Body Corporate Committee's process to enforce bylaws starts out in an informal way, so raising the issue to the attention of the tenant or the occupier. In this case, a tenant is breaching the bylaws because their dog is barking. So the Body Corporate Committee has written to the tenant saying, your dog's barking. One of the conditions of your approval for the dog was that it had to be, well behaved, and you've shown that the dog is barking, causing a nuisance. So we're taking away or rescinding the approval for the pet. Therefore, the pet needs to move out. And if the pet stays in the building, the tenants will be in breach of the bylaws. So that's the circumstance, and that's correct. The next steps, if the tenant does not move the pet out of the complex, or if the tenant themselves don't move out of the complex, then the tenant will be in breach of the bylaws, and the Body Corporate Committee can issue the tenant with a notice of contravention of the bylaws or bylaw breach notice. If that doesn't work, then the steps are the conciliation and adjudication processes, which are run by the Office of the Commissioner for Body Corporate and Community Management in Queensland. So that's a Queensland government department which provides that conciliation and adjudication service. Those, I would say in my experience, resolve 99% of all of the bylaw issues in Strata. So conciliation at the Office of the Commissioner for Body Corporate and Community Management, so the Commissioner's Office. Conciliation is a process where the parties come together and discuss the issue and come up with a mutually agreeable compromise, basically. Those compromises or those agreements are non-binding, but they typically solve most problems. If they don't solve the problem, the next step is adjudication, which is where an adjudicator will make an order. Those orders are binding. If a tenant then goes on and continues to breach the adjudication order, that becomes effectively a breach of a court order or a tribunal order, and that is the process that can end up in the Magistrates Court. It doesn't happen very often at all. In fact, it's quite rare, and it's very serious. So if you go before a magistrate and you've breached an order of the Commissioner for Body Corporate and Community Management, the magistrate can impose fines which range right up to many tens of thousands of dollars. So it is a significant process. The Body Corporate, at the point of reaching the Magistrates Court, it has left the Body Corporate process behind, and it's entering just a general litigation process. So that's the point at which, if the Body Corporate has not had legal advice to this point, it should definitely get it before commencing Magistrates Court action. In the Office of the Commissioner process, the conciliation and adjudication, most of those would be run by committees directly. It doesn't really require any knowledge of the law beyond, a normal person's understanding and interpretation. So most of the time, that's just a common sense forum, and outcomes can be reached without a solicitor on either side. Whereas in the Magistrates Court, you're exposed to the full requirements of court procedure, which are very difficult to navigate, and it's not something that the Magistrates Court will hold your hand through like the way the Commissioner's Office can do. So The body corporate is not required to engage a solicitor for a magistrates court action. It can self-represent, but it is significantly more difficult to do that. And unless your body corporate has someone very experienced in that type of work, or happens to have a lawyer or a solicitor on the committee, it's something that would be generally advisable. And the solicitor can also give you the prospects of whether you're likely to succeed or fail at that opportunity, and what the costs are likely to be. But it's generally not a cheap exercise. It would be several $1,000s to start with to get to the magistrates court. But the good news is, it is uncommon, because look, it happens probably less than once every couple of years across our portfolio, whereas the number of commissioners' applications for conciliation and adjudication can be quite high. Most of them just get resolved at that stage, and or if it's a tenant, the tenant moves out before the process can reach the magistrates court stage, because they'd prefer to move to a different location often, rather than deal with a committee for a building where they're just a tenant.